Good afternoon. I'm Tom Leonard, Senior Fellow and President Emeritus at TPI, and welcome to this afternoon's privacy panel, where we're going to discuss the issue of how the pandemic has changed our views on privacy and what that implies for legislation. Congress has been debating federal privacy legislation for some 20-odd years, but with increased urgency recently following the adoption of GDPR in Europe and state laws in California and other states. At a recent Senate hearing, a group of former FTC chairs and commissioners representing different parties and different points of view were all supportive of strong privacy legislation, but there are many specifics to be worked out. Ensuring that a privacy law yields net benefits requires answering questions about how to make the inevitable trade-offs and who should be responsible for making them. Those questions are more important and more difficult today, given the data needs associated with the coronavirus crisis and its aftermath. This panel will discuss the trade-off between privacy and beneficial uses of data in the context of the coronavirus pandemic, the impact of privacy considerations in fighting COVID, and what a new privacy law should include, and by implications, what it should not include. We have a very distinguished panel to discuss these issues, and let me introduce them now. Jane Bambauer is a professor of law at the University of Arizona. Christina Montgomery is vice president and chief privacy officer at IBM. Maureen Ohlhausen is the former acting chair and commissioner at the FTC, now a partner at the Baker Botts law firm. Andrew Smith is the head of the Bureau of Consumer Protection at the FTC, and Catherine Tucker is the Sloan Distinguished Professor of Management at Sloan, MIT. Let me start out with a question for the whole panel, and maybe also take you in the same order, in alphabetical order, as we started out. Has the coronavirus pandemic changed the trade-off between privacy and beneficial uses of data? And if so, how? Do you want to start off, Jane?
Sure. Well, in terms of where the policy debate is going, I have found that the pandemic has done surprisingly little to change how we talk about privacy law and policy and the trade-offs that need to be made between privacy and other values. Early in the pandemic, I thought that this was going to be a sort of watershed moment where we recognized that very strong static forms of privacy, the sort that GDPR incorporates, where consent is the main model, not the exclusive model, but the main model for allowing data to be collected and processed in almost any way, that would prove to be, it would prove to not serve what we're trying to do with the pandemic. So when South Korea was using data very aggressively in order to do contact tracing and do quarantines of individuals, at the individual level, rather than closing its entire economy, I thought we were going to wind up in a heated but productive conversation about what type of privacy is the right goal or objective, given the context where something like a COVID app might help give us some collective benefits. That has just not happened, though. Instead, there is a sort of persistence of distrust of government, of big tech companies, such that no matter what types of reasonable trade-offs might be made, I think people still feel like they would be foolish or naive if they were to recommend using communications technology in order to help curb the spread of the virus. So, when I look at the types of COVID apps that are in use here in the US, they are useless, and they're made useless. They were made useless because of the privacy norms and public, the way that the public debate wound up emerging with the expectation that the apps would have to be voluntarily used without any pressure whatsoever, no pressure on consent, and that the apps would be limited to only one form of data, basically the Bluetooth signals. So watching the development of the COVID apps has really been sort of, it's disappointed me in terms of having a substantive a debate about the types of trade-offs that privacy law is going to have to make.
Well, that actually leads into a lot of other questions, but why don't we go through the rest of the panel and see before we get to them. Christina, do you want to take that question?
Yeah, I think from my perspective, I'll pick up on what Jane was saying about trust and the lack of trust in tech companies. For my perspective, speaking from a tech company, from the beginning, I don't think there's necessarily a trade-off between privacy and public health, but we were very conscious from the beginning at IBM in ensuring that we maintain the trust of consumers and users of the technologies we were deploying, because of the sheer recognition that, if you don't have trust, the technologies aren't going to be adopted. And if they're not adopted, they're not going to be effective. You look at something like a proximity notification or exposure notification app, and it's simply not effective if it's not universally adopted by some significant percentage of the population. So working within those boundaries, and also working within and staying true to our values and principles as a company. We were facing these issues very early on in the time frame of COVID, because we had a lot of people within IBM who wanted to respond immediately to solve problems, right? Put our technology and put their talents to use to address the pandemic. And we put a process in place to ensure that technologies we were deploying were consistent with our principles for trust and transparency. So we released principles a number of years ago around trust in technology that essentially say the purpose of AI is to augment, not replace humans, that data and their insights belong to the creator, and that new technologies, including AI systems, have to be deployed transparently and explained in a transparent and explainable way. So with solutions that our teams were looking to deploy in response to the COVID pandemic, we kind of firmed those up and supplemented those with some guardrails specific to COVID technologies. And when I say COVID technologies, I'm talking about things like Jane mentioned, the exposure notification apps, social distancing detection kinds of technologies, fever detection, health passports, all those types of things that very quickly companies were looking at as helping to solution, some of the public health concerns with respect to the pandemic. And so we put together and published a set of principles around those, or guardrails rather, around those kinds of technologies that were very focused on things like data minimization and purpose limitations, deletion at the end of use, ensuring privacy and security by design, ensuring you had humans in the loop, thinking about inclusivity of those various technologies and that they were fair and inclusive as well. And we called on the broader tech industry to adopt those as well. Because again, I think it really does come back to the fact that we're very conscious of ensuring that the public trusts in what we're deploying. And again, if it's not trust, if trust isn't there, it's not going to be adopted. So it's that fine line for us.
So, what do you think? What do you think the level of, have we attained the level of trust so that these things might be adopted? Or it's a little late in the game, but.
I think what you're finding is it really depends on where you are in the world. There's different notions of what consumers in the US believe and will do and will voluntarily do versus consumers in other parts of the world. And you've seen those different approaches by governments around the world to addressing the pandemic. And as a global company, when you want to be as consistent as possible in terms of what you're deploying, particularly when we look at our own return to the workforce and the tools that we're going to use to help keep employees safe in the workforces in the 170 locations we have around the world, it's challenging for a global company. So we have to have a consistent set of principles that we apply around the globe, because there isn't necessarily a consistent view of trust or what's, okay from a consumer perspective in various parts of the world.
Maureen, you want to take it?
Sure, happy to. So there's a lot of different sources of law that we might consider protecting privacy kinds of values, right? It's not always just a federal privacy law or even a state privacy law. And early on in the pandemic, I found with counseling clients, a lot of things were changing, and they were changing because of the pandemic. There were state declarations of emergency that preempted some of the normal kinds of restrictions that you might see on sharing data about whether somebody had a diagnosis, on letting their employer know. The EEO changed some of its rules about what information employers could ask their employees. Have you traveled to a spot where COVID was prevalent? Why were you sick? You called in sick last week. Was it for a COVID related reason? And then things like taking temperatures and contact tracing and things like that. So there were a lot of changes. Well, I don't know if they'll end up being permanent changes, but they were done in reaction to the pandemic, and counseling companies on the fly on how to adapt to these, saying like, oh well, this emergency declaration came out yesterday. what does it say? So I think there were definitely some changes. Now Congress did, there were some interest in Congress in coming up with like a COVID specific bill. There was the Consumer Data Protection Act, and it was supposed to cover purposes like contact tracing and compliance with social distancing and tracking the spread of the virus, and had some prohibitions on how data, you needed to have affirmative express consent and notice of the purpose that it was being collected, and it would have preempted state laws. But we didn't really see that get a lot of traction. So it was introduced, it didn't really catch fire. And I think in some ways it's kind of been overtaken by events with interest again in an overarching federal privacy bill. So I think, then there's the third factor, which COVID really impacted, which was the huge move to transacting business online, doing, remote things like we're doing right now, and employees working from home, and, school being remote. And, some of the privacy implications of that need, careful consideration. There's, risks of, new risks were being introduced, right? With employees accessing things, remotely, or is someone's Zoom, meeting address being broadcast out to the world. So I think there were some things that, again, everyone using these technologies had to adopt to. And we saw some changes in, I think some kinds of, previous employer concerns about these things, kind of getting over it and just having to handle it, because that's how business had to continue. Now, moving forward from there, I think it's much more likely that we could end up with sort of a more overarching solution that is not COVID specific, but would have implications for how privacy and consumer data is treated and protected going forward, that in some ways it would be better. I think Commissioner Wilson talked about this, better to kind of have something in place that's more flexible and dynamic, that would take care of, a lot of different situations that could happen, not just a COVID specific kind of approach. So that's still to be determined. And we'll probably talk more about that. But those are the changes that I've seen during the COVID experience.
Andrew, how does it look from the vantage point of where you're sitting in front of the FTC building?
Right. Well, so this is a great panel and a lot of different perspectives here. From my perspective, I think that the laws that we enforce at the FTC have proven to be pretty adaptable and to allow beneficial uses of data that they need to allow while still protecting privacy. So I say that, that's a big distinction from what some of the other speakers have said. So there may be employment issues. I mean, I can easily see that, or healthcare issues, or issues with laws in other countries, which and for example, we talked about the experience in Korea. But from my perspective, so let's take as an example the Children's Online Privacy Protection Act, which was, right at the beginning of the pandemic, front and center with the distance learning and the distance learning apps. And that law requires parental consent in order to collect data about children or from children, and which are defined as anyone under the age of 13. So what we said pretty quickly is we put out guidance under COPPA, and we reiterated guidance that we had already issued with respect to distance learning, saying that schools can give this parental consent, but only for educational purposes, only for the collection of information for educational purposes, not for commercial purposes. Other laws that we enforce, like for example, the financial privacy laws, always include exceptions for responsible uses of data, such as data security or fraud prevention or IP protection or sharing with service providers or product improvement. And so I think that, we haven't seen so much of a conflict, but it's interesting that all of the speakers so far have talked about trust. And I think that's where a federal privacy law could come in, could be very helpful in terms of building trust and setting a baseline for data to help consumers build trust in these contact tracing apps. I also agree that the experience with contact tracing apps has been pretty dismal so far. I don't know whether, however, that's a function of privacy laws or a function of the approach that we've taken in this country with the contact tracing apps being sort of run state by state boards of health. And so it relies on those state boards of health to develop the apps, and then for the apps to be interoperable among one another. But that would be an issue, with respect to contact tracing apps in particular. We are interested in the privacy protective aspects of those, such as the use of Bluetooth data and decentralized data in order to make the app operate. Also, from our perspective at the FTC, we are concerned about, it's not just a privacy issue for us, but also a fraud issue. And so what we have seen are some scams that revolve around contact tracing. For example, scammers will send a text to a consumer's smartphone, and which will purport to be a contact tracer and include a link, which if the consumer clicks, it downloads malware. There also are people reaching out to consumers purporting to be contact tracers, and they're collecting financial information or social security information or immigration information. So we've been heavily invested in consumer education to tell consumers, look, you need to engage with contact tracers, but if they ask for financial information or social security number, or if, don't click on any links, don't give any of that type of information to the contact tracers. So that also is an effort in our own way to build trust. But I think the long and short of it is, we think that the laws that we enforce have been adaptable to the crisis. And that I do also think, though, that a broad federal baseline legislation, like some of the folks here have said, could let companies know the rules of the road and give them some clear guardrails to make them more comfortable with sharing and using information in order to combat the pandemic.
Thanks. Catherine, have the trade-offs involved in privacy changed due to the COVID pandemic?
Right. Well, I just want to echo, a lot of what we've heard from the panel. So I think Maureen's point, which is one way of thinking about the pandemic, which is an acceleration of trends towards digital and giving us advance notice about where the economy is going and where maybe risks we want to be thinking about, is a really good one. I had three main points I want to make about the trade-offs. The first one is, I actually very much agree with Jane that there's been surprisingly little talk about privacy, really. Given we sort of thought in March, that might be all we're talking about. There's been less than one might have thought. I think, what I have noted is that certain industry sectors have done in some way a very good job of demonstrating the public value of their data in a way which one might not have anticipated. So I'm thinking, for example, of the industry around location data and gathering that data from apps, and that's been sometimes somewhat controversial, but I think that industry's demonstrated that there is potentially a huge public health benefit from that kind of data, and I know lots of regional governments are now using it. I think there actually hasn't been, and sometimes, enough talk about what the pandemic has revealed about the kind of privacy laws which are not doing what Andrew's talking about, which is instilling trust, facilitating the exchange of data, but instead really just stopping, in some sense, or halting the exchange of data. One of my research projects during the pandemic has been looking at how health privacy laws have prevented the reporting of data in a timely and accurate way to public health agencies. And I think we've seen there in that research several instances where there just seems to be laws instituted for an earlier era, which are lingering in a digital era and no longer seem well placed. And I'm thinking of the kind of laws which prevented the easy transmission of health data from nursing homes. I'm thinking about the laws which makes it easier for health providers to be compliant by sending faxes than using digital interchanges. And I just think, if I was to be more, I guess, out there than many panelists, I would say that for me, the pandemic has made me at least focus again a lot on the issues of health privacy and how to have efficient health privacy laws in an era of digital data rather than commercial privacy or privacy around advertising, which we've been discussing for so long at Aspen. The other thing I want to say is we talk about trade-offs about privacy. The third thing is that for me, it's just laid bare that we keep on having this conversation about privacy and somehow assuming that the data is being created. And if you think about the location app tracking debate, we immediately jump there. And I think that's what Jane was thinking of in March and April, to be sort of thinking about that and thinking about how to protect people's privacy. But there wasn't much discussion about people who don't have smartphones. The fact that elderly people over the age of 80, only 35% of them have cell phones, that wasn't part of the discussion. And for me, again, it meant, it's highlighting that we discuss a lot of trade-offs about privacy, but we're often presuming that the data exists and people are generating it and not really talking about data exclusion. So I'm going to stop here, but thank you so much for letting me give all these.
I think that does lead into, and I think Jane was, maybe I'm misreading. I think Jane was suggesting this in her opening remarks, but let me just ask the question about whether privacy requirements or privacy considerations that were not really requirements have basically changed the, changed the costs of fighting COVID, either in terms of other health effects or in terms of economic activity, or both. I mean, I guess.
Yeah, I did want a chance to clarify that I think actually I'm a little bit at odds with other panelists, because although I am concerned about the level of public distrust, I think one of the causes of it, my diagnosis is that there is an unjustified level of distrust right now, and that we're all somewhat responsible for it. That by focusing on, by contributing, I guess, to the sense that companies, large and small, are constantly misusing data and flouting the law, we get the impression that without new federal regulation, something like GDPR, we are unprotected as consumers. And that's just not correct. I mean, the FTC, I agree with Andrew, the FTC actually has found a way to craft some flexible rules that don't satisfy some consumers, but I think do strike a totally, a very defensible balance between innovation and the control of user data by the users themselves. And this perception that that Apple and Google will keep our data keep the Bluetooth data indefinitely, or will combine all of the data with other things and do, just exploit a COVID app as much as possible. And that if any data were given to the CDC, then the next thing we know, the FBI will have it. This perception that every possible risk is a risk, no matter what laws we have in place, that really got in the way. I mean, I think the reason Congress didn't pass a law might be because it didn't have to, because Apple and Google was so far ahead of the public relations crisis that it was about to have, that it just said that its Bluetooth technology can't be paired with GPS, period. And so when a company is fighting a broad perception that consumers are constantly exploited and abused by not only the big companies, but also the small companies that sort of make use of their services, then they are understandably reluctant to make an app that can actually do a good job of putting together useful data for public health purposes.
Anybody want to comment on that?
I mean, I think speaking from the company perspective, that's absolutely true, right? So we have to assure consumers as a provider of some of these services that we have at the heart their interests, that we're going to responsibly steward new technologies into the world, clearly, transparently, and with privacy and security at the heart of everything that we do in order for them to trust us. And that's a constant consideration from an IBM perspective. And it's one of the reasons I think why, we are supportive. And I know we're going to talk about, the US landscape and national privacy legislation. But I do think, while I don't disagree that there are laws out there that, are broadly protective of consumer interests, I also do agree that from a perception perspective, if nothing else, that a nationally uniform, consistently applied foundation of privacy legislation in the US could help to build consumer trust in technology companies.
But is the bottom line, and then we'll move to the more general privacy legislation, is the bottom line that concerns about privacy basically trumped, it just made it much more difficult to have an effective strategy against COVID, which obviously has huge costs. Would people agree or challenge that statement?
So I think it probably depends on the context, what you're talking about. I think that there are probably some businesses that have, been able to take advantage of the flexibility of the laws that we have. We talked about, for example, the distance learning. And there are probably other businesses that have been stymied by the lack of guidance. I will say that with respect to the contact tracing apps, we issued some guidance pretty early on, which was really very basic, but I think it was all of the principles that we're talking about here. So we said, for example, tell people why you're collecting the data. Only use the data for that purpose. Only keep the data as long as you need it for that purpose. And then there is this ingenious idea that some of us have touched on, which is having the data be decentralized and living on everyone's device, and only, so it collects the Bluetooth signals that you have been close to over a period of time. But there's not one big central database of everybody's location all the time. all of that went a long way to building trust. And I think that, actually around the world, the contact tracing apps that have used that Apple, Google methodology have been relatively well trusted. Why there hasn't been a lot of uptake in this country, I agree, is discouraging. But I'm not sure that it's due to the privacy considerations, and maybe more due to just the logistics of doing something like that on a national level in this country.
So here's the rub. I agree with Andrew that the Apple Google system with Bluetooth, decentralized Bluetooth is well trusted, but it also does not do much in terms of actually being able to provide a better risk score and a better notification than we could do using more traditional means. The nature of collecting Bluetooth only and not GPS means you're lacking a lot of contextual clues that might have some hope of doing better risk scoring. Centralization also helps risk scoring, because then not just whether a person has been in contact with another person who is actually tested positive, but you have more data to sort of figure out each individual's risk in terms of whether they've been in contact with someone who is in contact, so more than one hop, so to speak, to use national security lingo. And so I do think that the distrust, which again, arguably, from my perch, seems to be exaggerated or not totally squared with reality. The distrust has gotten in the way of companies being able to feel like they can help actually make an app that's likely to do contact tracing well and to do risk scoring well. They have to choose between that or being trusted. There is not a way to get both. And I'm not sure that a federal law that basically codifies the expectation that data will be minimized, that in some ways, Apple and Google did exactly what a popular federal law would require of them. They said you can only collect one kind of data and you can't centralize it. And that, though, impeded the efficacy.
Well, let's move on to the discussion of general privacy law. So I guess there's pretty widespread agreement that we should have a federal privacy law. Of course, there's been fairly widespread agreement on it for a number of years, and it hasn't passed. But I think maybe there's more agreement now than there was before. Let me just ask a basic way: has the COVID affected the type of law we might get? It seems to me it probably has had little or no effect. But
so maybe I'll take that one, Tom. So my sense, so I testified on federal privacy law before the Senate Commerce Committee in December of 2019. And I did it again about 10 days ago, 2 weeks ago. And I didn't see any change in the bills and the law based on COVID. Right? There wasn't something that now is the COVID section. I'm not saying that is a failure or inappropriate, but I don't think, other than, as I already mentioned, this kind of recognition that COVID has accelerated our use of digital, which was pretty strong to begin with, but I think it's, even stronger and in more facets of our life than people maybe previously, telemedicine and remote learning we've talked about and things like that. But I think it has not impacted the federal bill, the wording of it, the provisions of it. It may help with the idea that it would have been a useful thing to have had in place when, something like this hit. And, look, I agree, with Jane. I think some of the concerns about, how companies were going to use data and things like that may not have been particularly well founded, but they were enough to keep consumers. Well, I don't know if that was the only reason. I mean, there's lots of holes in our COVID response, I think. But it certainly, could have been one of the reasons. And I think the other thing that we need to mention is all of this is taking place during a time of great criticism of particular tech companies, right? The techlash, and, we had House hearings. I testified in front of those. We just had a big report from the House Judiciary Committee staff. And so that is part of the environment as well, where I think critics have certainly been strongly vocal about whether tech companies should, could, can, will be trusted on a number of fronts. And I think privacy is just part of that larger debate that's happening.
So let's talk a bit about what we think a federal privacy law should look like. First, let me ask the question to kind of, well, at least to get it out of the way. And so should we have something similar to a GDPR or CCPA approach, or should it be different in fundamental ways? Don't all answer at once, but.
Well, let me jump in there, because I've been pretty critical in my research about GDPR, at least, and its effects. And I think, I think in some sense in the US, we should be saying thank you to Europe for experimenting in a way which means that we can learn. It's not clear to me that in particular, the EU Privacy Directive has struck the right balance between competition and privacy. And I think there's a lot we can learn about dealing with the unintended side effects of GDPR in reinforcing potential sources of incumbency in data. And so I think, we should say thank you to the EU, learn from it, but it shouldn't necessarily be a model given, the costs, which are now quite well documented.
Well, should we base our privacy law on kind of on a notice and choice type of approach that's been talked about for a long time? Some variant of the FIPS, or should we try something different?
So one notice and choice can sort of span a rather wide range of, depending on what you mean by choice. To the extent, one of the things I've been most critical of the CCPA and GDPR for is the idea of non-discrimination once somebody has chosen to either delete their data or not opt in to a data collection scheme. Because if you're saying that the service has to be identical, whether someone gives up their right of control of their data or not, then it's if we think of personal data as being the kind of price that everyone's paying for a good, it means that there's this weird cross subsidy between the people who do share their data and those who don't, and that then overall there's just less. It means that the services themselves will be affected in some way. I've been working with the Uniform Law Commission to develop a state-level privacy act, and for what it's worth, we're trying something that's a little different from FIPS and from GDPR. It's actually a little more similar to, I think, what the FTC has been developing through its fairness, not just deception, but also fairness doctrine, where we're trying to define compatible uses. So, we're defining categories of compatible, incompatible, and then prohibited uses, where prohibited uses just can't be done, or prohibited data practices can't be done no matter what. And then if you're in this incompatible range, you need the kind of affirmative consent that, GDPR and CCPA, or at least GDPR has in mind, rather. And then compatible uses, though, can go beyond just the very narrow purpose for which the data was intended, as long as there are, it's reasonable to anticipate that there will be shared benefits with the consumer. So we're trying that. I'll let you know, how contentious it is.
So what type of uses would be prohibited outright, and what type of uses would require?
Well, so So like failure to engage in, failure to do sufficient data security would be a prohibited data practice, for example. And then certain things that would be illegal anyways are listed in there. To some extent, some of the prohibited uses codify things that state tort law has sort of homed in on as being an inappropriate use of information anyways. Many things though fall into the incompatible category. So
Is this I mean, I think you and other people have talked about kind of a duty of care, which as a non-lawyer, I'm not entirely sure what that means, but is this somewhat similar to that, a different way of getting to that?
yeah, the conversation around fiduciary duties that might be applied to tech firms, or digital firms, is related, except that I think once you start talking about things like not only duty of care, but things like duty of loyalty, it starts looking stronger and stronger and more like we're having tech firms in a similar position as doctors and lawyers. But a duty of care in terms of a reasonableness standard that gauges whether you need to actually give just in time notice and get that kind of consent or not. I think that's a fair comparison. Yeah.
How much we should retain of the kind of the existing FTC framework, and how, and kind of like what harms should a new law or a new framework be aimed at addressing?
The federal bill, it does talk about things like some of the concepts that Jane is talking about is more geared to what the sensitivity of the data, right? So, which I think in implicit in that is this idea of what harm could result from it. So if it is sensitive data, where you could see that it could be used in a way to discriminate easily against someone, or to steal their money, or stalk them, or something like that, you need to get the affirmative express consent. For non-sensitive data, you don't, right? It's more of the opt-out. And then the bills have, because I think this awareness of the need to allow the free flow of data to create new products and to have innovations and the kind of value of that. You also have no restriction, no real restrictions on de-identified data, or I hate to say this word, pseudonymized data, because I'm not sure I ever say it correctly, but the kind of data that you say, well, that's not going to be used to harm a particular person, and you might have contractual, protections around it. And then, some of the other provisions also to allow the use of data, have things like consumers' access to data, right? That they can find out what companies have, that they can delete it, right? Or they can correct it. So a lot of these rights build on things like the Fair Credit Reporting Act kind of approach. There are beneficial uses of data that consumers may not like in their individual, no one wants to have their bad credit reported, but societal wise, they're beneficial. So the way we balance that in the Fair Credit Reporting Act is that consumers get to know how it's being used. They get to challenge it, right? They get to find out, is there something in my file that's causing me not to get, the special, particularly important benefits like employment and, insurance and things like that, housing. So some of these concepts, I think, are being brought into what the federal law would look like. So while it's not necessarily saying like, unfair, deceptive acts or practices, or, the unfairness formulation that the FTC has used to great effect, I think a lot of these concepts are being put in there with the idea that we're trying to prevent clear harms to consumers without the consumer, agreeing to it, right? That they might say, I want that risk. I'm happy to, there are things that people share on websites willingly that I think all of us would be a little surprised that they share. But if they know that that's what they're doing and why, and, that I think we're not supposed to be replacing consumers' choices, right? We're supposed to be facilitating consumer choices. So those are some of the things that I've seen in the federal privacy law. It's I think some of the important things it also has is it does keep the FTC as the enforcer there. It's not trying to create a new, at least the main privacy bills that are in the Senate Commerce Committee, as trying to stick with the FTC as the enforcer, and to give these, kinds of abilities and rights. And as you mentioned, Tom, some of the sticking points are about, well, what about the states? Are the states preempted? Do we use an approach where the states can enforce the federal law like they can in the Children's Online Privacy Protection Act, but they can't do something different with it? So those are some of the hard sticking points that I think still need to be worked out. But there's important overlaps that I think bring together, maybe in different terms and imposing different obligations that grow out of a lot of I think the FTC and the Fair Credit Reporting Act, and a desire not to create some of the challenges, hurdles that we've seen arise from things like GDPR.
So we're actually running out of time. So let me close with an easy question. Actually, it's two questions combined. Should the FTC have, in a new act, have rulemaking authority, and should there be a cost-benefit requirement for new FTC rules? Let's go around and people can answer that briefly. You want to start, Christina?
I would say some limited rulemaking authority. I sort of like the approach that's in the current proposed bill, where the FTC is the enforcement authority, but we expand that enforcement authority to some extent, enabling the FTC to levy fines for harms to consumers without first having to enter into a consent decree, for example. So I think, because a lot of what we talked about today, it's pretty clear there are rules that are out there that we could apply, that we could expand upon. And the FTC, in IBM's mind at least, is the right place to have that enforcement authority in the privacy context.
Catherine, should there be a cost-benefit requirement for new FTC rules?
Well, it sounds like a bit of a job creation program for economists, doesn't it, really? But more seriously, it worries me. And it worries me because we got so much research showing how difficult it is to calibrate anything about privacy costs and privacy harms, because they tend to be so perceptual. Customers are very uneven in the way they respond. There's this privacy paradox, which makes all measurement tough. I think until we begin to grapple with that and have a clear sight about what we mean by cost-benefit analysis, we could be facing some, very difficult decisions.
Andrew, of course, when we started doing this with, with environmental regulations, it was pretty primitive too.
Right. So, I should have said probably at the beginning of this that, given my standard disclaimer, that I speak only for myself and not for the commissioner, for any individual commissioner. But here I can actually say that our commission has testified in favor of data security legislation, and 4 of 5 have testified in favor of privacy legislation. And the one thing that's common, I think, to the testimony and that they all agree upon is that we should have civil penalty authority, like Christina mentioned. We should have expanded jurisdiction over common carriers and nonprofits, and we should have APA rulemaking authority. So that means rulemaking under the Administrative Procedures Act, which does just on its terms does require some analysis that you actually articulate a problem that you're trying to solve, and you have and your solution has a rational basis to that problem. And there also are now EOs, executive orders, some of which may apply to the Federal Trade Commission, some of which do not, that also require some amount of cost benefit analysis. So, but we have said, our commissioners have said that we should have rulemaking. I think the idea here is not broad rulemaking to set the policy choices about collection, use, sharing, choice, access, the types of things we've talked about, but rather those policy choices should be set by Congress, and the FTC should have rulemaking authority to fill in whatever blanks might naturally occur in that type of a statutory scheme. And that rulemaking should be under the Administrative Procedures Act, and not anything gussied up or additional requirements that you don't find in the Administrative Procedures Act.
Jane?
So I think I'm on record from a previous proposed bill of suggesting that the FTC should have a limited rulemaking authority, but I want to especially emphasize the importance of cost benefit analysis, because while I recognize the concerns that Catherine rightly has, I think the only thing worse than cost benefit analysis is no cost benefit analysis, because privacy, I mean, it has a tricky accounting where people, it's very easy to lose track of the benefits when you're losing control of your data.
Maureen?
So I'm also in favor of the FTC having limited rulemaking authority where Congress sets the parameters and then the FTC does the rules to carry it out. When you look, I often like to look back on what's worked pretty well, right? So like when you think of the Children's Online Privacy Protection Act, which I already mentioned, where Congress set kind of ideas of like, these are, this is the, age 13, that's where we're setting the rule. But for what is going to be personal information, that will change over time. So the FTC should have the authority and the ability to keep up with technology to do that. But it doesn't open it up to like free, kind of free range, any ride to the rescue of any kind of problem that someone may say should be solved by a federal rule. So I am in favor of that as well. And, I'm a big fan of the Executive Order 12866 that sets out all those kinds of, I'm not sure it's applicable to the FTC, but I think it's a good idea for any agency when making rules to consider those kinds of factors to make, an effective rule that also keeps it out of trouble. Because I think when agencies overreach is when things then start to get challenged and they may end up worse off than they were when they started.
And I want to just reiterate what Maureen said, is that I agree that this should be carefully cabined rulemaking, that Congress needs to make the big policy cuts, like we said, about whether consumers get a choice, what information can be collected, when can it be shared, that type of stuff. But within that there needs to be someone who has rulemaking, and that someone, I believe, should be the Federal Trade Commission. And it should be in the rules, we should not be so confined that it becomes impossible to make rules to fill in those blanks, right? I mean, we want this privacy scheme to work. And I could imagine a situation where we are so burdened with additional requirements that it would be hard to make the rules that are needed to make the system work.
Well, these were all great comments. We are going to move next to audience Q&A, but we'll stop here now and take it up again next Monday. So let me start with a question for Christina. Christina, yeah.
Yep.
So you talked about doing some things to increase the level of trust in tech firms, tech industry in general. I think with respect to things like COVID information, but also much more generally. So I guess I have two related questions. One is, what would you do to try to build more trust? What measures could be taken? And maybe in the context of that, you could also maybe address Jane's point, which I understand, is that she thinks that the level of mistrust is not entirely warranted.
Yeah, I mean, I think it goes back to some of what I mentioned earlier in terms of the approach that we took, articulating principles, but then demonstrating that companies are going to actually live by the principles that they articulate, and having an accountable framework in place within the company to demonstrate to clients, to demonstrate to investors that you are actually taking those steps. So we've done all of that, going back to the principles that we articulated around trust and transparency. And some of those are, as I mentioned, ensuring that when you're releasing new technologies or whatever you're doing with data and offerings and the like, you're clear about what uses you're putting data to, for example. You apply principles such as data minimization, depending on the type of data, that you take a risk-based approach, where you're looking at the use of a particular technology, the end user of a particular technology, and assessing the risk associated with that. So it's those kind of laws ensuring a lawful, fair, transparent, secure, inclusive approach to technology, and then having a process in place to ensure that you are carrying that throughout your company. And that's what we do in part through our AI ethics board at IBM. We take use cases through this process. We run them through a filter on a global basis, a globally consistent way of ensuring and holding our company accountable for the technologies that we're deploying. And we talk about that publicly, and we build on that process publicly. And we come out with, from a policy perspective, what are our recommendations? What are some concrete, actionable recommendations that policymakers can take, that other companies can take to assure consumers that you are actually living by the principles that you're articulating. So that's what we do internally. And then I think, as a tech company and as a company that, and in a role in a company where I see how we make these decisions, I personally feel as if, in some cases, trust is unwarranted. But that's only going to be proven if companies follow through and demonstrate the accountability and how they're living by those principles and those practices. So we have to earn it. We have to continually earn it in the actions that we take, in how we talk about technologies, in sharing and being transparent about the technologies that we're deploying and the like. So that's what we try to do, at IBM to help that conversation.
So one of the things that you mentioned, I think, as a measure to build trust is not using data for unanticipated purposes, and this is something that's been talked about for years. But of course, it could be that there are unanticipated uses of data that could be very beneficial. There might be unanticipated uses of health data that might help at some stage give us a better idea what we did right or wrong with respect to the COVID pandemic. So maybe the panelists could discuss a little bit more how we should treat unanticipated uses of data. Maybe you could talk a little bit more about it, Christina, and then maybe the other panelists.
Yeah, I mean, just briefly, I think there are measures that, for example, privacy enhancing technologies can be put to use and put to better use. And that's something we're looking at IBM today through our research team, is how do techniques like differential privacy or federated learning, how are there ways to use technology, to use data, maybe for unanticipated ways, but in ways that people won't be concerned about that use, or that will comply with privacy laws around the globe, because you've either anonymized or pseudonymized, or the protections that you're putting in place are enabling you to protect that data, not expose privacy, and put it to beneficial use. So I think technology is one way that can help that.
Would anybody else like to comment on that issue?
Well, go ahead, Catherine.
Just say, that there's a lot which has been very persuasive that has been written about the idea of privacy in context and how retaining the context is very important. But I think COVID does show us some of the difficulties in always that being the best policy globally. So I'm thinking, for example, about the amount of mobile data that was generated in March, which in retrospect is really, really useful for understanding exactly why it was certain nursing homes were affected more adversely than others. Now, in general, that mobile data, there was not an expectation when you were creating it that it would be useful in a public health crisis. But in retrospect, the advantages of having access to that data does seem to outweigh the usual privacy in context considerations. So that's just an example, but I think certainly when we usually think about data reuse, we're not generally thinking of a large shock or a set of unanticipated circumstances like we had here.
Jane?
Yes. Yeah, I largely agree with what Catherine said. And just this morning, I learned that the French High Court, I believe, had to reverse a ruling related to their central health database because the French government was working with IBM to host the data on IBM servers, and after Schrems.
Microsoft, I think.
I'm sorry, Microsoft, you're right, totally right. Sorry. And after Schrems 2, there were concerns that because Microsoft could not guarantee that U.S. government, wouldn't use a FISA warrant or something like that to access the data, that the GDPR should sort of impose and stop the use of this centralized database, even though it would, it's being used, data is being used for the COVID crisis. The French court ultimately decided that because the data was pseudonymized, this is like the uses are important enough to outweigh the concerns. But I think it's a nice illustration to show that, even when we are sensitive to context, there will be differences of opinion and in terms of the trade-offs and the risks that we're willing to take and what we perceive as the benefits. And, just an enduring problem is figuring out how to assess efficacy without trying things that seem dangerous or figuring out what types of processing or unintended processing should be off limits without knowing enough in advance about what would emerge if we had tried it. So.
Well, somebody has asked a question for Jane. Do you think people were actually concerned about privacy with respect to the COVID apps, or was it mostly advocates saying they were?
Well, in April, I was paying attention to the public polls, and there were some really interesting findings. The general public were more willing than you might think to have the government itself, for example, collecting GPS or data, the sort of data surveillance that apps could enable. And minority groups were even more likely to be in favor of that. I think it's because in April, we were also discovering that the risks of COVID were not evenly distributed themselves. So I think there was more of a public appetite for these types of apps than among the elites or among the more politically connected. But that said, even those surveys were still finding that people were almost evenly split. And so, we do have, even in the US, sort of two cultures of privacy in terms of willingness to take risks.
Let me ask Catherine a question related to what you were talking about and what you talked about earlier. I think you were saying we should, in light of the COVID pandemic, we should, I mean, people are not talking about doing this, I don't think, but we should revisit some of the health privacy laws in terms of what we could do with, I guess, what we can do with health data and what we can't do. Do you have some more specific suggestions about what we should look at?
Yes, I mean, so it's what struck me about the debate about privacy during the pandemic, was, there's been a focus on contact tracing apps, which seems pretty much, well, I don't know if it's like first, it would be the first place I would go, simply because it's such a huge public good problem. Thinking about getting the adoption of contact tracing apps in place, that would be the first place I'd go if I was worrying about them from a policy perspective, how to solve the fact that really, it's very difficult to induce adoption of a public good. What does strike me is that we have, though, found during the pandemic the continued costs of outdated laws. And that's what I think the sort of pandemic should wake us up to. And I gave a few examples during the panel, but I'll just reiterate them now. So for example, because of, in some sense, uncertainty about interpretation of the law, there have been various states which have decided against sharing data on which nursing homes have been affected. Just like, and it's all about how do you even interpret who a person is and so on, things which aren't really of the digital age. The other thing that the pandemic has uncovered in the health sector is that because of the nature of the variety of privacy laws, we're still seeing doctors interacting with public health authorities using faxes. And, faxes are great in the analog world in some sense for comporting with privacy laws, but it does suggest that if we've got this sort of reporting lag in data, which is due to using faxes, which is due to using the privacy laws, that things like easy things we can tackle to sort of update these laws. So I think it's not, the costs I'm talking about is having privacy laws lingering from the analog age, and we're really seeing the effects, I think, in the health sector in terms of the speed of reporting and the type of data that's able to be reported.
But nobody's really looking at that in Congress right now, are they? As far as I'm aware. But speaking of Congress, let's end on a. I realize none of you probably advertise yourselves as political prognosticators, but let me ask the question and get each person's sense of whether they think the probability of getting a national privacy law in 2021 is greater than 50-50, and whether that depends on who is in control of Congress, which party is in control of Congress. Should we start? Let's start. Well, let's do it in alphabetical order. I hate to pick on you, Jane, but let's do it in alphabetical order again.
I would still put the chance at below 50%. I think that although there are reasons that both parties would be interested in showing sort of strength against the power of big tech, the actual political trade-offs that have to be made are too contentious. And so I think the substance of the bill is still too hard.
Christina?
Wow, pure speculation. I think a lot of work has gone into crafting bills on both sides of the House. I think there is discussion right now in terms of how to compromise on the big issues that remain to be solved, but they're hard issues to solve.
Are you talking about the state preemption and the
private right of action? I think they're really hard issues to solve. So I guess I would put the odds at 50-50 that we get through it next year. I don't know how to prioritize it more than that. And I think it does depend on, whether you've got one party in charge of Congress could make a difference as well.
Andrew?
Yeah, so, prognosticating the likelihood of a law, that's sort of a no-win proposition for me. And I'm not a legislative guy anyway, but I do hope that if there is a law, the versions that I have seen have a role for the Federal Trade Commission. And I think that that's important because for the last 50 years, since the advent of the Fair Credit Reporting Act, we've been enforcing and interpreting and making rules under information privacy laws. So we have a great deal of experience with it. We know how to protect consumers. When Congress has given us specific authority, whether it be the Fair Credit Reporting Act, Children's Online Privacy Protection Act, the Gramm-Leach-Bliley Act, the Gramm-Leach-Bliley Act Safeguards Rule, the Telemarketing Sales Rule, Can't Spam Act. We've used that authority. We've brought cases. We've made rules. And we've even used our organic authority to prohibit unfair and deceptive acts or practices, which is an imperfect tool. I think all of our commissioners have recognized that that's an imperfect tool, both because of the breadth and sometimes the imprecision of those requirements, and also the limited relief that we're able to obtain. Imperfect though those tools may be, we have used them, and we've brought almost 150 cases over the last several years in both the privacy and the the data security arena. So we think that we're up to the task, and we hope that if there is a law that Congress enacts, that the FTC has a role to play in it.
Maureen?
Yes, thanks. I think it's important to understand, I think what you are asking is whether there will be a federal privacy law.
Yes.
Right.
That's
But
right.
I think there's a difference between a federal privacy law and a national privacy law. Because if we have a federal privacy law, which I think might be about 50-50, that doesn't preempt the states, we still won't have a single national privacy law. We will have a federal law, and we will have a variety of state laws. Right. So I would hope what we would get would be both a federal and a national privacy law. But I think it's important to understand that there is a difference between those two. If we're looking for a uniform law that applies across businesses, across consumers, doesn't matter, where the different parts of the transaction are happening, where the buyer and the seller and the processor and the controller and all that is, I think we do need a federal privacy law that's also a national privacy law by setting that standard, again, with the ability of the state AGs to enforce it. And I think it would be somewhat ironic if we ended up with a law that actually created even more of a patchwork, because the impetus behind GDPR, one of the reasons for it, was because of Europe's push to have a single European market. So they wanted a single privacy law rather than all the different, country level ones that they had previously under the data directive. So I think we should take a lesson from that and try to also achieve that, because we do truly, and on so many areas, have a national marketplace in data and in commerce.
So you think it's plausible that we could get a federal law that doesn't preempt the states?
I think we could, if, depending on what the election results are.
Catherine?
Well, we've had such great comments. The only thing I have to add is that it does strike me, this is highly dependent on where the state of the economy is. And when I think about the biggest shifts in privacy law, at least at the federal level, something like HIPAA, that was very much associated with a huge federal investment in a certain sector of the economy, in this case, digital health records. And I wonder, if we're in that same state too, whether we might see more of an impetus for federal regulation, say if we see a similar investment in remote learning tools or educational technology. So that's all I have to offer. But my gosh, what great comments from the rest of the panel.
Well, I agree. There were great comments from all of the panel, and I appreciate it very much. And Thank you.